Thank you. Well, I'm the president of the Kingston, but you are the senior deacon. Thank you. We have some apologies for absence, I think. I said I have from Mr. Pernell Charles Jr., who is off the island, and so I think is Mr. Somebody is on. Mr. Jackson is on, so we don't need apology again. You'll be on. We'll be good to have you. Senator Dr. Scott Motley apologize for absence as well. So let's welcome the team to another sitting. Today we are going to have some of our contributors and interested institutions on the Firearms Prohibition, Restriction and Regulation Act, namely the Jamaica Rifle Association, Jamaica Customs Agency, and Mr. Champagne. I want to thank them for their interest and their contribution. We'll have to take it in some order. The JRA was maybe the first body to respond, and I gather the first this morning. Mr. Ricky, it's good to have you together, represented by Mr. Major John Nelson, retired President, Dr. George Stewart, and Mr. Rich.
Ricky, but that's okay.
That's his name and nature, so we'll leave what the other name. Of course, I have I'm a Commissioner of Customs, Ms. Van Marikis Walker. Good to have you this morning, along with Mr. Nicely and Ms. Crystal Corbett. And Mr. Champagne, I gather, is come with a team as well. They are not in yet. Mr. Richard Lynch and Mr. Pagan. We're going to start with the Rifle Association. Be good to hear your perspective on the new bill. This bill is being introduced to update it's a repeal of the Firearms Act to bring a new bill, which we think is more relevant to the current needs in the country. The primary interest, really, it will bring good order to the firearm regulations. We think not a lot of changes there. It will also allow us to honor some of our international obligations. But critically for us in the government is to isolate the illegal weapons, which we now classify as prohibited weapons, and associate those who are, and ensure that those who are associated with such weapons are given appropriate penalties. It is our biggest security threat at this point and the biggest source of disorder in society. Our homicide rate remains the highest in the world. Not just the highest in a democracy. In fact, most democracies that have this level of violence is in a level of disarray and turmoil. So it's a credit to the society for being able to stick together as a democracy with this kind of rate of homicide. It's a clear and present danger. In fact, it is amazing the level of tolerance society have shown. But I said it is allow us to, we have been able to survive the liberal democracy, which we sometimes take for granted. We've had, 70 plus years of ongoing elections and change of government routinely, despite the hiccup in the 80s. And a relatively speaking hiccup. That's what we have as a country, which we sometimes take for granted, but is maybe the only democracy with this level of violence that has survived with that level of stability, and which we have to seek to protect. Currently, I said the rate of homicide is not only traumatic, but disrupting a lot of activities before democracy survives. It impacts our development. It impacts our inter-economic development, and some of us sections of society literally operates as outside of the normal life, and members of the community always feel at risk. Therefore, critical that we get this piece of legislation to at least ensure that there is a major disincentive to hold a firearm. And that is the fundamental piece of the policy, that we want to ensure we have legislation, ensure it will become a major deterrence to those who hold firearms, so the penalties will be so adapted. Firearms kill, but these people use firearms to kill. That's our biggest problem in the society, in the country. So the holders of such firearms will be held accountable in a very severe way. And the messaging as the regulators for regulators is that the pistol is still a weapon of death. And therefore, while they have it legally, it must be managed in a very strict and transparent but disciplined way, because once it gets out of the line of the legal side, it's a weapon of death. And no other way to describe it. It's the most dangerous piece of equipment in the Jamaican society. And that's how we have to treat it throughout the system. But it also gives us the opportunity to ensure that in separating them, we can have a management structure a regulatory structure for the legitimate firearm holders that is, while rigid, must be simple and manageable. While sending the message for, that it is still a weapon that must be handled with care and a sense of responsibility. So welcome this morning, leading our discussion. We have our committee, our joint select committee, but in the House with us this morning for the members who are here, Minister Marlene Malo-Fort, our Minister of Legal Affairs, who will lead this question from the floor, Senator Golding Campbell from the Senate, and of course, Mr. Donald Williams, MP in Central Kingston. And we have online Senator Charles Sinclair from Montego Bay, but from the Senate, Mr. Fitzjackson, member from Portmore area. So welcome to everyone. We're going to begin with the Jamaica Rifle Association, who I gather has submitted an amended submission. Minister, we can go straight to the presenters, right? And so I want to thank you all for your submissions. This piece of legislation, besides having outlined the risk we face and where we have moved towards it, it's a major piece of legislation. It's over 100 pages, sections, but it also has some innovations. Even the separation of the illegal firearms into the prohibited weapons is innovative. We did a lot of research on legislation across the globe, and that was our primary, policy shift. But it took us a while to get it right, to get the structure right. So there are some innovative things in it, and I expect there will be comments on all of them, and we're happy to have the comments. But as I said, the policy indicated just to indicate where we're coming from and how seriously government review the issue, but we need this piece of legislation. I think everybody agrees we need this legislation. Just we have to make sure we get it right, which is why we're having the Joint Select Committee, and I've invited comments from him. Now, Major Nelson, I gather you're the president.
I am, sir.
You're leading the submissions, or I presume, and a president of the association, and a former representative of the country in pistol shoot and other things. An Army officer as well.
Good morning, Chairman.
Morning again. Welcome.
Members of your committee present, and those that are on Zoom that have joined us, and to the other visitors that are here, and participants who are involved in this process. I wish to extend my appreciation for this opportunity to address you, sir, and your committee on behalf of the over 900 members of the Jamaica Rifle Association and the over 200 of the Jamaica Ski Club. Allow me to introduce my team. I'm Major John Nelson. I'm a retired officer of the arguable finest organization in Jamaica, the Jamaica Defense Force. And I remain committed to say that despite my years of retirement. I'm here as the president of the Jamaica Rifle Association, and with me today is George Stewart. He's a long-standing member of the Jamaica Rifle Association, and he's also an attorney, and he's one of the two members that took on the job of providing the technical response to the Firearm Act. And the other member, Matthew Smith Barrett, he is not here, but he spent long hours. So I'm asking you if you'll allow me just to express my collective thank you to both gentlemen. They work long and they work hard. So I thank them both publicly. Robin Rickey is here. He's a former vice president of the Jamaica Rifle Association, and he's a member now and vice president of the Jamaica Ski Club. And he's here today in the event that you have questions you wish answered as it relates to the Jamaica Ski Club. As you would expect, Chairman and members, we have a team at the JRA that follows each and every day of the proceedings in here. They report back with the positives and, of course, the negatives. And we have also noted, by and large, the negative responses that have been voiced as it relates to what takes place here. But contrary to that, we, the JRA and the JSC, have seen nothing but positives. This is something that is long in coming, and we're very happy that it is happening now. Of course, there are issues we have with it, but we also believe that at the end of it, Jamaica, and by extension the Jamaica Rifle Association and the Jamaica Ski Club will be better served by this new act. I will be doing my presentation on why I and the members of the JRA and Ski Club believe that shooting sports are of utmost importance to all of us. I will make every effort this morning to convince you all of the value and the follow-on process for young boys and girls to become involved in the sport of target shooting. Upon my presentation, George Stewart will address a number of technical related matters. Chairman, members, I'm not sure if you're aware that some 50 years ago this year, shooting in schools ended. The government, you're aware. The government ended shooting then, this year, so it's befitting.
I think the best range was at Cornell College.
They had a shooting team. They came last every year, but they had a shooting team. In 1972, the government then ended all forms of target shooting in schools. School shooting at that time was very popular, as was athletics, football. It was no different. Follow-on attempts in the years did not in any way have an impact on getting it started. You're here today, Chairman, and you are absolutely gung-ho on seeing it start again. I know that. You can well understand the excitement that we feel at the JRA and Ski Club to know that you are all sitting in here and developing something that will see the restart of schoolboy and schoolgirl shooting in this country. This is not about the individual me, and I have a story to tell, and bear with me. And this is the best part of the story as I start. I attended Jamaica College. And there's a pause. In the very first week of my attendance, a young man my age walked by, and he was dressed in cadet uniform. I inquired, and eventually I became a cadet of the Jamaica College unit. But best of all, the cadets had rifle shooting, and Jamaica College itself had target rifle shooting. Some years later, I made the Jamaica cadet shooting team, and I went to the Twickenham Park range to compete in the All-Ireland Cadet Rifle Championships. And at those championships, I finished first. Some weeks later, I was called to the principal's office, and I was introduced to the president of the Jamaica Rifle Association. And just as if it was yesterday, he said, "Son, would you like to join the Jamaica Rifle Association?" Just as I was about to leave Jamaica College, having undergone training at the JRA and transported by my seniors to Twickenham Park Range, I was selected on the national rifle team to represent the country at the World Target Rifle Championships in England. The JRA at that time had many JDF personnel involved in the sport, and I was subsequently invited and was successful in gaining acceptance to the JDF. And I was helped in no small way by my skill at target shooting. Target shooting has been amazingly good to me. I have represented this beautiful country of ours hundreds of times. And this includes many, many countries at the highest levels of competition. And I've even received a nomination for Sportsman of the Year for not athletics, not cricket, but for target rifle shooting. Chairman, members, we have submitted a proposal to offer the sport of target shooting to our young boys and girls, many of whom these days are spending their free time playing electronic games and getting into all sorts of other mischief. And we understand your views on saying that the Jamaica Constabulary Force is the direction we should all look towards starting this program. From last year, in the middle of last year, we approached the Jamaica Constabulary Force and offered an opportunity to them to start. The Commandant, Brigadier Johnson, was very excited, and he decided that he would have a cohort of 16 to 20 young men between the ages of 12 and 16 develop to become a part of this program. He liked it, he loved it actually, as did his senior officers. And we addressed to him our plan of starting these young men and women to the president of the Jamaica Olympic Association, Mr. Smudo, who in turn visited the GRA. He looked at our facilities and there and then pledged the support of the JOA to the start of this program for our young boys and girls. We would in turn approach the Jamaica Defense Force to provide us with, if not a current senior non-commissioned officer, recommend to us a retired senior non-commissioned officer that would head up this program. A program that we regard with the utmost seriousness. These young men would report to the Jamaica Rifle Association each Saturday morning at 9 o'clock in uniform, and they would spend the day with us from 9 until 4 p.m. They would be inspected, and they would have the very, very serious issue of how they looked in their uniform. But this is not just about target shooting, Chairman and members. They would be in receipt of classes to involve subjects as civics, health, deportment, speaking with confidence, putting on presentations of their own, and they would also be afforded a lunch put on by us, the GRA, a seated luncheon where they would be introduced to the proper use of the knife and the fork, which plate to use. And I just want to add, because many of us may say, well, my child would know that. As a cadet, I went to the Royal Military Academy, Sandhurst, and the very first week of attending there, we all had to learn how to use a knife and fork, including the British cadets. We're going to replicate it in this program, and we're going to teach these young men and women, young girls, how to sit at a dining table, how to be served, and how to eat properly. They would serve themselves, and we would monitor their habits. It's a one-year program, and at the end of that one-year period, if they wish to continue to the next level of target shooting, they would join us again, but in a different area of practice. If they don't wish to, we are hopeful that we would have turned out a well-rounded and developed young person. We would have trained them to understand that the gun, the same gun you speak of, is a gun of violence, but is also a gun that teaches you discipline, patience, concentration, and that is the idea of what this program is all about.
President, Minister Ford wanted to ask you a question.
Yes, please.
Thank you, Chairman. Major?
Yes, ma'am.
What age group are you talking about for
Cadets.
this? What age group?
Oh, 12 to 16.
Right.
I'm sorry.
So your concern is about the age that is prescribed for authorization with a firearm user's permit?
Yes.
All right.
And the second part of it is that starting at a young person at any age after 16 in learning is pretty much a no-go. They need to be in there at 12 to 16. And George is going to address the question of what can a 12-year-old use as far as a rifle or a pistol goes? What can they use? What would they be allowed to use? Not the guns that Chairman is speaking about, but air rifles and air pistols, which is completely different.
Right, so currently the limit is set at 16, and that is...
There's no limit. No permit is given to us. No, that's in proposed law.
Right,
Right. There's no
I'm
pistol
speaking
shoot.
to the bill.
I know, yeah.
I'm speaking
Right.
to the bill. And that is the issue of concern. You're asking the committee to consider lowering the age because of what the program involves.
Right.
And you're saying that it goes beyond training in the use of firearm, but you're assisting to produce well-rounded individuals who
That's
are
right.
socially agile.
Yes, life skills. We are hoping to do.
Go ahead, Minister. You have to. The issues in section. The point you say, you have made a comment on it, and we'll take it. And what I'd like you to get into the various clauses which we are looking at, because the issue of the age for permit, user's permit, is one of the submissions you made. I think that's section. Where you did start your comment from section 2 through to a number of very useful comments which we need to discuss on the policies. I think the question of user's permit is
The issue of the permit is contained in clause 2, which is the definition section. But I think in the interest of time, we could go to the clauses.
Oh, well, let's take the submission here as a full submission, and I think we should go through it to get to the debate on it.
Okay,
Discussion on the age ranges.
Okay. May I continue?
Yeah, go ahead.
Okay, thank you. Minister and Chairman and members, I'm going to close off by just giving an example of the importance of the age as it relates to us. In middle of last year, we received a request from a 14-year-old who lives in New Zealand, a Jamaican, who wants to go to the Olympics for archery. We are not here to discuss archery, but I'm bringing the relevance of it to everyone here. Continued investigation showed us that she had to attend a qualifier to be held in Puerto Rico 2 weeks ago. And she paid her own way from New Zealand with her coach to come to Puerto Rico for the qualifier. I approached the GOA and they said they don't support qualifiers, but they paid their own way, $7,500 US, and she qualified for the Pan American Championships. Another qualifier for the Olympic Games.
You're referring to archery?
She's 14 years of age.
Yeah.
Okay? And the point I'm making here, Minister, please, the point I'm making is that she started in the sport at age 10, and at age 14, she's ranked 7 in New Zealand, and she's training now to go to the Olympics. We have not had that opportunity with target representation, and that is why I've brought it up to show that if we are allowed to have air rifle, air pistol, .22 rifle training for 12, 13, 14-year-olds, we have the same opportunity to try out for the Olympics. It's an Olympic sport. Thank you, sir.
Once you go to the sections, we discuss them objectively. You know, there's a couple of coincidences here. Watch, you know, you draw New Zealand. You have 1,100 members. We kill 1,100 people every year with guns. What? You have 1,100 members in your association.
Yes.
This country kills 1,100 people every year with guns, on average, for the last 20 years. No, that's about it. In addition to that, New Zealand, where the lady lives, has a homicide rate of about 2 in 100,000.
Correct.
We are at about 48 per 100,000. We have to take note of all these things. I'm saying it is a total negative, but all these need to be factored into consideration when we do the thing from where we sit. The entire picture of the frame have to be borne in mind, not just one corner. So let's take the bill as it is, and we give you a fair set at it all. And the comments are valid, so let us see if we can go through them. Yeah, the section you're referring to is primarily confined to Section 66, Clause 2, I think, for user's permit. So it'd be good if we just go through and settle. The quality of the bill is important overall for both the country and for your association. So, and I think all aspects, you have made comments which are responsible comments to look at how we can ensure that we have a better bill. So let us go through it, and we will give you a fair hearing on the, as I said, and all the members here in looking at the user's permit. But you had comments from Section 2 going through pretty extensive, must be one of the more extensive comments from the GRA. Yeah.
Morning, Chair, members, others here. So let me start out by saying right up front, we are in total support of the efforts to curb this monster called crime, particularly as it relates to gun crime. Let me be clear, in no way, shape, or form are we advocating that firearms should be in the hands of minors unsupervised. Let's be clear. What I'll attempt to do today as I go through the sections, it's primarily more asking questions for clarifications, because we recognize that based on the use cases that we have seen, there are chances for misunderstanding. So I want to start with Section 2, the interpretations. And the first one is the firearm. And we are pointing particularly the one that affects us most. It's Part B. And it reads, firearm means any that includes any part and components of any weapons referred to in paragraph A. Here is our challenge with that. Assistant Superintendent Bernard was here, and we listened. And I think he helped, so we don't have to go and frame that again. He did an absolutely marvelous job. And he made the point about he did not consider, or the Institute didn't consider a firearm without a magazine as a complete firearm. The challenge is that if you speak to any licensed firearm holder, or you see a purchased firearm, is that it comes with 2 magazines. So one magazine is in the gun, and that's a complete firearm. If we go by this interpretation, that second magazine now becomes a part of a firearm, and therefore it's a component and it qualifies under this to be deemed a second firearm, for which you run the risk of being charged. So we are making the point that it requires a qualification. And the qualification that we are suggesting is that whatever that component is, if you don't have a permit for a firearm to which it attaches, then it should be deemed as a second firearm. And a broad enough qualification like that solves the problem without having to get into specifics about the parts and the myriads of combination of things. Otherwise, we are going to have to delve in too much detail to think about every possible combination of things that is permissible.
We did discuss quite extensively, and the ministry team is on. Remind me, Mr. Bailey or Mr. Richard, because I think we had clarified this without any problem in the discussion. We understand that.
Just to be clear, that the current definition of firearm includes component parts.
Yes.
Right. The definition here is going to be looked at, but not so much from the perspective of whether parts and component of the firearm will constitute a firearm. But from another perspective, but the policy is that parts and component are included in the definition of a firearm.
I think you'll accept that, Minister, just to clarify to prevent the licensed firearm holder from having a part that is not charged on the same prohibited weapon.
Right.
I think the technical team had asked him to comment because we did discuss this quite extensively, and in fact, when you're here, so in how we avoid that. Ministry? Coming in. What is happening, You're on. Mr. Richards, are you hearing us? Please.
It is the parts and component of the firearm that you're licensed to possess.
Yeah, but it's just that
Right.
when a licensed firearm will buy a butt-fire gun, you want that to be avoided. And we did discuss it and agree. It was agreed to how to correct that. I just don't recall exactly how. It's not a challenge. The clause is not a challenge to the members. It's just to ensure that the component, when he's going to a gunsmith, for example, to make an adjustment, which is indicated. But please, Mr. Richards. Team, we're not. This wasn't really a debate issue. We agreed that there has to be I'd agreed. So just want to be aware of what it is, because if you have no license, a prohibited weapon, and that's not a debate. It is just to ensure we have it covers your authorized persons. Yeah, can you hear me now? Back on. Are you hearing me now? Yeah, why did you just to as a prohibited weapon? Yeah, if you have no license, you're going to be treated as any other prohibited weapon.
So the intention is that the authorization would cover the parts and component of the firearm
Yeah.
for which you're authorized to carry.
Right.
Yes.
Yeah.
If that is the concern.
That's the concern.
Yes.
Yeah, and it's accepted. It's just to make sure that the law is clear. You're a lawyer, so we did discuss it quite extensively in the committee. So this is not a. What I do, I make a note and I'll show you that will be dealt with. That there's no confusion. I'm still trying to get our members on. Can I call them from now? Eh? Yeah, the existing law, but they want to make it clear that it is. So we'll. Can I show you of that? Okay. Section C. Oh, we need.
Well, I'm not going to cover all of them. Some of them I will just keep based on the discussions that I've heard. So I'll move on to firearm user's permit. And I just want to point out one small concern there, is that under the definition of a firearm, air rifles are excluded. However, this provision references authorization for air rifles. The definition of firearm user's permit. So this is subsection. Section
No,
2.
not at all. What's happening? Sorry.
Well, it's just a definition.
What section?
No, just a definition. Firearm user's permit. Section 2, under section 2. Well, I just read the section. It just says firearm user's permit means a permit authorizing an individual not younger than 16 years of age and not 21 years of age or older to possess and use a shotgun, air rifle, or ammunition with the permission of the principal holder of the firearm user's license for that shotgun, air rifle, or ammunition, as the case may be. It's just that the definition of a firearm itself excludes. So we're just asking that we'll be mindful in making a decision if we're going to exclude air rifles from the definition of firearm that we made the adjustment here.
The current definition includes a rifle, and you get a permit from FLA. The current status.
Current as it is
Yeah.
now.
I think that has to remain as it is because it's not a challenge. It's almost a routine activity.
Right.
I'm going to ask the ministry team to come down because they're not hearing properly, and we need to have them here because most of these clarification, we did discuss them, clarify them, and we're going to make note, and it's best if they're here. So I've asked them to come down. They're not far, so they should be in a few minutes. But again, this too was taken into consideration in the discussion in committee. We had agreed to this already, that what stands, what is on now will stay, right? And it's not a major challenge.
Okay. All right, so I'll move on to the firearm users restricted license.
Right.
And it means a license authorizing the holder thereof to A, possess, and B, use only within an approved control area specified in the license, which may include a firearm shooting range or gun club. Any firearm or ammunition specified in the license. So we just had a couple of questions there. So that we understand in a policy perspective because of the concerns that we have, if there's a lower age limit, so we have a sense as to what this license in particular applies to, and a sense as to what is the outer limit in terms of a time period that a person could obtain a license like this for.
All right, this is your firearms use and permit you're referring to now, right?
Yes, the firearm users restricted license.
Yeah. Yeah, well, as said, I think your President in the opening remarks, there was no debate on the issue of airguns, shotguns, and shotguns. I think it was inserted in the law, but we agreed that that is the current standard can be remain and the age limit for those are accepted. The debate is issue of pistol and rifle shooting. Right? There was a debate publicly, but there's a bit of a misunderstanding. We don't have any concern with air guns, shotgun, 20 gauge, and shotgun. It's skeet shooting, which is an existing club and practice by many, and we're not breaking that. But the pistol and rifle shooting is one of concern.
Chairman, I understand the inquiry a little differently, though. I understand what Dr. Stewart is saying is that the definition of firearm excludes a rifle, but the definition of a firearms user's permit includes a permit for air rifle. Right. And that is a matter that we will have to cross-check.
It came up in the earlier
if it is not included in the definition of a firearm, the question does arise as to why would you need a permit for it? Is it an omission on the other side? It is currently excluded in the Firearms Act, the one that is in effect now. So, excluded.
Minister. In the earlier section, you had clarified that.
But I see the issue, and we will cross-reference and check.
So we're now on
the discussion of the
on
classification of air guns. It came up in the first section for definition, and we did discuss it and settle it. All right, Ms. Grant is online. I hope I can hear her. The CPC. CPC, go ahead.
Thanks, Chair. I was just pointing out that the definition of firearm does in fact include air rifles. Under C, air rifles would only be excluded if they're of a type or caliber prescribed by the minister. So there's no exclusion of air rifles generally.
We did discuss it extensively in the committee. Most of these are, the discussion really should surround rather than taking time is whether we bring in the rifles and the pistols. That was the debate we had. As the President indicated in his opening remarks, the air rifles we accepted. We did accept the air rifles and the shotguns.
Chair, yeah. Can you ask CPC to just repeat her explanation again? It's not so clear to me.
It is. Right. The remark that was, or the comment that was made was that air rifles were not included in the definition of firearms. But I'm stating that that's not correct. Under C, air rifles are included. They would only be excluded if they are of a type or caliber prescribed by the minister. That is what C says. If you look at C of the definition of firearm.
I think it was understood differently.
But we don't, I think I said the area of this here is just a matter of this language. We don't have a debate on, and the policy doesn't reach, accepts these. The debate is really about the reintroduction of pistol and rifle shooting at a lower age. And so as the President indicated, this was discontinued back in 1972. In fact, the cadet continued for a while, and that was discontinued again at a later stage. Cadets, I think, were allowed to shoot until almost the end of the 80s, early 90s. And I indicated that, I don't know, when it was withdrawn by the threat assessors, that given what the emerging use of guns in criminal activity in Jamaica, it was withdrawn by the government from the schools. From that point of view, it's not a good time to look at it again, when the use of firearms has increased significantly and exponentially as a criminal weapon. I did indicate that I would be willing to consider looking at it being used by members of the Cadet Corps, because when the Cadet Corps was doing it, the rifles were stored at the JDF reserve camp, and those in charge were, of course, associated with the JDF. And I said it was, at that time for me, it was still a consideration, because it's not currently a sport in Jamaica, so I'm introducing a gun sport in plain language, which is not currently practiced. No, nobody uses those rifles except for adults. We know we have a pretty strong core of target shooters among adults. The question is it a good signal at this point in time to introduce a gun sport, which is not being practiced now and has been discontinued for many years. Pistols, rifle shooting for children have been discontinued for nearly 50 years, and in schools as a general sport, and a specific training among cadets about 30 years or more. One have to ask the question, is it a good time to consider reintroducing it? Because it was withdrawn not without due thought by the authorities then, and it was considered treacherous by the people, by those then in charge of the country. And it was discontinued for both school, which was a sport, and then it was discontinued by cadets, where it was part of the training. In the case of the cadets, we looked at. But again, not many Caribbean countries, have practiced rifle shooting as a sport. But the Latin American region is still the highest region for homicides. Jamaica is the highest in the globe, and the Caribbean, Latin American region has the highest as a region. And therefore, there's a level of restriction and rifle shooting for children. That is where it is, right? Minister?
Well, Chairman, the issue would have to be resolved outside of this forum because it is a policy question. I know there are conflicting goals. So on the one hand, as you've rightly said, sports shooting in schools was discontinued. On the other hand, Jamaica has a proud tradition of athletic competition, and it is the wider sporting policy to enable and encourage participation at the highest level. And if Jamaicans are to compete in any form of shooting, then they would have to be enabled at the various stages so that they can acquire the necessary skills to ultimately medal in the competition. But we have a context where the use of firearm poses such a threat to national security and defense of the realm that we lean towards restricting. But the good thing is that the minister does have big policy remit here. and we will take the concern where the policies are settled and noted at this time. For clay shooting, let me be very clear. It slipped in the bill at age. There's no problem. We encourage it. It's something that has been well established in Jamaica. I made a comment in one of my reports that the shotgun in Jamaica is not even seen as a weapon by most people. It is a sporting equipment. For those who have thought criminals have replaced that a long time ago with other things. That's what it is. So we don't have to delay ourselves and debate that.
there is concern at the rifle shooting. I said I attend the school with a rifle club. If we were not the best shooter, we had the best range. and I was a short-term member of the cadet. Something happened, I stepped out. But the cadet was also going through a time of repositioning, because when the rifles were taken from the school, the cadet went through a bit of a down and up, and you know, it was not the best time for the cadet corps.
Mr. Chairman?
But, yeah.
Might I direct a question to Dr. Stewart and Major Nelson? Is it correct to say that there was a time when pistols and rifles were permitted by youngsters in schools? During that time when you had shooting in schools, were pistols and rifles part of the permitted firearms that age group had access to?
Rifles were .22 rifles, no pistols, but .22 rifles were allowed, and the cadet force used what was then called the 303 rifle.
So is it the GRA's position that they would wish to see pistols and rifles being used?
Air rifles.
Air rifles.
And air pistols.
Okay. And so could you clarify for me, how does an air rifle work? What does it discharge?
Right. It discharges a very small pellet that is just larger than, say, you taking your pen.
Is that what I call a BB gun?
A BB gun.
Ah, okay. That's what you call an air rifle.
Pretty much so, except that the pellet is now designed to aerodynamically move through the air.
That's President. That's something. Air rifles is not an issue, you know.
Okay.
Right?
I'm just
two rifles is a rifle. You have rifles, two rifles are rifles, and discharge around that can kill.
Two rifles are not an issue either, Minister. Two rifles. I'm sure that if you go through the records, you will find no history of 2.2 rifles being used in any form of homicides here. None.
But it's a rifle.
And pistol, not just a rifle. A 2.2 rifle will go to 50 yards. Pretty much that's it, 50 yards. And then it starts falling dramatically.
Yeah,
I know.
I'm aware of that.
It's not a weapon of choice for a criminal.
But within the 20-yard range, which is more the range they use now, it will hurt you.
So, Chairman, the real legal policy issue.
I'd have to. Oh, go ahead, Minister.
I'm just saying, Chairman, that the legal policy issue is whether the government will create a room for the authorization of persons below the age of 16. Now, the age of criminal responsibility is set at 12, so it is going to be nigh impossible to go below that, if that is what you're asking for, because that is where age of criminal legal responsibility is set for children age 12 in this jurisdiction. So the question is between 12 and 14, or 12 and 16, or 14 to 16. That's where it would have to be narrowed. And then there are other considerations that would have to be looked at.
No, there are, as I said, the members of raised, I said, the sports shooting in its purest form, shotguns, air guns, from age 12, not a problem. The 22 is still a weapon, into the 22 pistol, which is, for the professional killer, can be a very useful tool because it's easy to conceal and you get nearby. It's not just in movies, in real life. It is a deadly weapon. It's just that the range is short. And as I said, one have to consider very carefully if you're going to reverse a long-standing policy. It's a policy to use such thing.
Chairman, if I could finish my question. I wanted to follow on Major Nelson to ask, now that you've clarified the issue of the air rifle for me, how long have you been president of the GRA?
2.5 years.
And a member for?
A long time.
Older than me?
You said, if you reminded you, he joined when he went to JC.
Yes, I suspect the answer to that is yes.
And member senator, he didn't transfer to JC like somebody else went. No, he went straight to JC.
Yes.
Transfer from JC to the JDF.
I see. In the history of your association with the organization, has there been, to your knowledge, any incident of any of the weapons, firearms, that were being used by license holders who were members, being implicated in criminal matters? Do you know of any such incident?
I don't. As I said earlier, the 22.22 rifle and pistol worldwide, not in Jamaica, is not a weapon of choice for crime. It's absolutely not. And I mean, this is evidence that anyone can find. It's also an Olympic sport. And that's the direction that we're trying to go in, that if we are allowed to use a 22 rifle and 22 pistol, we're able to train kids to not only be offered a scholarship to the United States for target shooting, but also to put themselves forward to go to the Olympics. Right now, as we're speaking, we have students here in Jamaica who are attending universities in the United States on shooting scholarships. But we are not open to do it for 22 rifle and pistol because the law doesn't allow it. The law allows it for shotguns. So we have kids overseas at universities on shotgun shooting scholarships.
No, it's a great sport today. You don't have to break that. And the clay shooting we have encouraged, as the one young man reminded me.
That's what we're asking for. Open it to the 22 rifle. No evidence of it in crime, Minister. None.
I wouldn't want to do it now, but I said we'll discuss it again at another level. Okay. I assure you, and I tell you why I'm leaning from it. You see, bear in mind we are now introducing some very, very stringent measures for the illegal firearm. Criminals adopt their own life, their style too. At 22. Is a very dangerous weapon at close range, especially a 22 pistol. In fact, some people project that is a favorite of the professional assassin in a developed society, because once you put the pressure on the more obvious firearms, the first one I tried to conceal what they have. So it's easy to conceal a 22. So instead of going to a bank with a AK-47 and become a powerhouse, the criminal walk in, quietly moving a 22 and put people under pressure. They will adapt because it's easy to conceal a 22. So I'm saying, while I discuss it, we have to be careful. The law will be reviewed as we proceed, and as I said, I don't feel very comfortable changing our policy at this point. When it was changed for a reason, I said among the threat risk scheme was because of the increasing use of firearms. So I'd be cautious on it. I understand your interest, Ms. and I know you're being a top sports shooter from an early age, and that the cadets enjoy the use of these things, but it was discontinued for that reason. In fact, in the case of the throw tree, I remember distinctly when the first event that they did was to spike them. The bore hold the top, so if you fight, it explodes in your face. And if you heard that at that time, you're aware of it, because they stole the first throw tree rifles from Woolmer's armory. Right? And then later on, they realized that even when they did this, which would damage the rifle, you could drill with it, but it would have been dangerous to shoot with it. They still had a problem, and they discontinued the entire rifle shooting, even the cadet. You only did it at camp, which is why I said it maybe could look at to reintroduce the cadets in controlled circumstances. We have 3 army bases across the country. There's the Burt Barracks in Montego Bay. There's the reserve in Port Maria and Mandeville, and there is the Monique camp, and of course, Upper Camp. It would mean we have also limiting the scope, but it might be a possibility. But I'd say let us discuss that some more. We take note of your interests, and we recognize the sporting facility of it. But I said, essentially, to reverse a policy based on a threat risk assessed 50 years ago, at a time when we were really going through a rough time, and you could also see how the new firearm restriction and the prohibited weapons operate, which would, if it functions as a real deterrence, then you can open up the legal side even more. And I said, right now we are looking at how we're making it easier for the legal firearm holder with the existing legal firearm regime. But maybe it's worthwhile. I'd ask JRA to maintain your interests, allow us to look at it, but consider that it's not an antagonistic view, but we maybe should hold a little bit. And if we have to make an amendment a little bit later, Remember, the minister has some discretion, and we see how the government is, but we do have a problem now with the kind of want and use. I know it's not a legal firearm, but it's just like, it becomes also a culture. If you notice, kids, the girls are carrying weapons in their underwear to school. So, if you, a knife, 6-inch knife is not much more than 22 pistol. You have a knife which is that small. We have to remain a bit careful, but we encourage you have the air guns, the shotguns, and that's now a very active sport to which you can introduce your kids to, and I know it is to be encouraged. It have to be associated with established clubs, which brings it with the discipline and the character development that goes with it, which is why I said the cadet may be a place to start. But let us hold the rifles for a little bit and see how we go with the new approach. All right?
Minister, and again, I understand the advocacy on our side. I would just implore the team and those listening to understand that there is still another layer of control called policy. When you actually issue the license, that you can stipulate at that point in time. So I don't think the door is closed. I understand the concern, but there's a middle ground because you still have the actual issuing of the license, and there's a layer of control there. So we'll accept and move on from there.
I appreciate it. Thank you.
The next issue, and this one is a small one, and this is for my archery friends. The firearm shooting range, and somehow the word, in the definition of the firearm shooting range, somehow the word archery got in there. And the suggestion is that if a set of persons wanted to associate just to shoot archery, that they would need a firearm shooting range license. And, on behalf of my archer friends, they are wondering what they have to do with firearms, and they think that they shouldn't be included in this.
The technical team's not here yet, but what's the current status on archery? I know it is something that have to give permit to be imported.
Right.
And therefore there's some control over the bow
the
and where it
importation.
goes. Right.
But after that,
and to whom it goes to, therefore. Right. And there's always a due diligence done on the person importing the bow as to why they're doing it, if it's not for a movie or something.
Right. And we're advocating because we're also the home of archery. So just that small...
Right. Again, the discussion was early in the game, the presentation. I want technicality to remind exactly what we decided on this. It was raised, and I'd make a question, and when they get in, I'd go back to it. I've asked them to come down here. Minister is looking at it.
Okay, we quickly move on to the issue of modification, but I think ASP Bernard made a presentation, and we are squarely where he's at.
Yes.
That shouldn't be as exhaustive as this.
Yes, I
because
recall
things
that.
like color don't really matter. I just make a quick plug for the people who hunt. You buy a shotgun, and the glare of the barrel will,
Put night sights on it.
Right. No.
Pistol.
People just wrap it with camouflage coloring or tape, and under this it will be viewed as a modification. And we are saying that we don't think that it should be so. But I think SP Bernard covered that favorably, I think, to the firearm community.
Proposal that came from the Mr. Bernard from the forensic lab, and I don't think there was any issue in doing that. Right.
Yeah. We're in full support of his submissions. So we move now to the substantive part of the law. So we exclude Section 2 because it has nothing to do with us. It's prohibited weapons. So we jump straight to Section 4. And the first section that we want to deal with is Section 40, Subsection 3, A and B. And it says, no person shall deal in firearms or ammunition except under and in accordance with the terms of a firearm dealer's license or a firearms broker's license, and we go to 3. For the purpose of this section, a person in possession of 2 or more firearms or 20 or more rounds of ammunition shall be presumed to be in possession for the purpose of dealing in firearms or ammunition, as the case may be. Now, this part is dealing with licensed firearm holders. Unfortunately, there are many of us who are lawfully in possession. We have authorization for multiple firearms. Taken as is here, we would deem to be dealing in firearms. So it needs a qualification except where you have the appropriate authorization.
Your question is whether you would be permitted to hold 2 or more firearms without requiring a dealer's license.
Yes, you'll be issuing a lot of dealer's license.
Or a broker's license.
You'll be issuing or 20 or more rounds. Today, the typical licensed firearm holder,
Right.
their permit allows them to hold 50 rounds. So all of us would require dealer's
But
license.
target shooters are allowed to hold, and the bird shooters carry more than that.
Well, we're just saying, right? So it needs
I think
qualification.
the issue of this coming in at the time, again, these are the lights found within the
Yes.
interrogate was, there are individuals sometimes, well, let me go a bit abroad. When you get to the NRA member, you like to have 40 weapons in this case. And I think the idea was to have some limit on this in terms of some people, the sport shooting has to be recognized, whether it is bird shooting or clay shooting or pistol shooting. But to just give a civilian 5-6 firearms, a different ballgame, just for the sake of having guns. I think that's really a concern because they are the ones who are attracting. But I'm waiting on, we did discuss this as well, and I know there was accommodation for your sport shooting to be amended to the law. I'm waiting.
Subclause 3 of clause 40 needs
A qualification.
an additional language which would accept persons who are authorized to possess those firearms. It is where you have no authorization at all. So you move from possession, simple possession of it, and depending on the quantity, you would move to dealing in it, if you are not so authorized.
Right.
Yes.
Accommodations will be made, Minister, to ensure that those who are in sport shooting, the bird shooter may take a box of, for 5 bird shooters, 100 rounds out there in the morning, right? More.
Or more.
More. So, similarly, in the context of sport shooting, when they're practicing,
Yes.
they might,
Yes.
they know you'll try with it, but they'll have a fair number. They're going to shoot hundreds of rounds if you want to be a good shooter.
Right.
So, that will have to be recognized by the law.
Right.
If the language.
Just a clarification here. I'm just trying to, through you, Mr. Chairman, I'd like to direct this question to Dr. Stewart. Perhaps it would have been more appropriate for a representative of the FLA, but Dr. Stewart, given his years of experience and association with the club and the FLA, could assist. Is it that currently a firearm holder, authorized firearm holder, currently can hold 2 or more guns?
2 is a small number. Just think about the people who hunt. So they typically would have a pistol and a shotgun. There are many of us who participate in multiple disciplines.
Okay.
And as a result, would have
Multiple licenses.
multiple. Let me
Okay.
just put it at that.
And as we would put it, that would be authorized. That
Yes,
is legal.
all licensed. All licensed.
Now, are you saying then that this provision, as formulated, 43, would prohibit such license or authorization to hold 2 or more, if it were to go through, if it were to be approved? Is that what you're saying?
I am saying, as is, it criminalizes many lawful firearm holders as we speak right now.
Yes, and specifically, does it mean that you cannot hold 2 or more after this?
Well, that's what it would suggest.
Okay.
It would be a criminal offense.
That's what I'm getting at. 'Cause the current law allows you to hold 2 or more.
Yes.
Yes. So you're saying this would radically change the current law. That's your position?
Yes.
Okay.
I don't see Mr. Richards here yet. Or Paul is here. I think we had settled this issue in terms of it's primarily sporting shooting where they've been carrying more than 50 rounds and that. And there is permission, there's authorization for that. If it's not in the law, we have to accommodate it. But I think we had agreed to that somehow in the beginning. Ms. White,
Morning,
Who's
Chairman.
speaking?
Sorry, I've
Where's
just
Russia?
arrived. Which provision exactly?
40 subsection 3 A and B.
We're dealing with the question of when you have a licensed firearm was allowed to carry 50 rounds, but there is section 43A. The sports shooter carries far more, and it doesn't seem to, the way it is written, doesn't seem to allow. Yeah, it doesn't seem to allow for that. So we're trying to get the language right. Yeah.
Chairman, we know what needs to be done to correct
we'll deal with it.
the problem.
Again, this doesn't breach policy. It's not a policy issue. It's more for the person who, I said, it is what the prohibited weapon, and if there's a registered weapon owner who gives it to somebody else and he's traveling around to go trade gun numbers, you can deal with, walking around 200 rounds to give to some criminal, different ball game. But the sports shooter, we have to accommodate it. So the language needs to be amended, and we agree. And we'll do that. I see members of the team here. Mr. Daniel, you want to come in?
Minister, sorry. My understanding of Section 42, Minister, is dealing with a dealer's license, not a user's license or a farm user's regular license. You can have multiple licenses for those, but this is a dealer, a person dealing, and what dealing means in the interpretation section. So possession is not dealing.
No, what I'm saying, 2 or more firearms or 20 or more rounds, that's an individual who doesn't have a dealer's license. But what they're saying, what they're asking is to make sure the person, what you're now assuming that the person who now has 100 rounds traveling around to hustle it illegally, we're going to lock him up, right? But this section have to give some recognition to the sports shooter who may be carrying more than that, although he has a license. He's not treated as a dealer because he has 100 rounds going to the bird bush. I think that's the concern they're raising. And it's a genuine concern. I just want to make sure it's clear. A man going to shoot at the range, who's a rifle shooter, target shooter, or someone going hunting, will need more than 50 rounds. And as what Mr. Stewart is raising, this doesn't seem to recognize that, and you don't want to get into a situation where you get a person being described as a dealer, taken to court, and he gets a mandatory sentence, right?
Minister, it's noted. In my record here, it is actually noted when we're going through that is actually. So
the language has to be
users
correct.
and a gunsmith is also would be included in that section.
Right, okay.
Yeah, so just to
These are things we have to do. We need this law, right? So it was discussed and, as I said, and noted, and we corrected.
Yeah. So I just reiterate for Mr. Dallin, because I heard his comment. It does read, for the purpose of this section, a person in possession of 2 or more firearms, that's A, or 20 or more rounds, shall be presumed to be in possession for the purposes of dealing in firearms and ammunition, as the case may be. It provides no exception for persons who are lawfully in possession, and this section is dealing with lawfully held firearms. So we just want to make sure we can't afford ambiguities.
Dr. Stewart, there is an issue that has to be resolved in respect of this clause. We know what it is, and we will discuss it behind the scene and report back to Parliament.
This is not a policy change.
I'm not going to say too much on it, but I know what the problem is, and I will discuss with the technical team.
Thanks. So I'll quickly move on. Section 44.1, and again, this is for my gunsmiths in here. It says, notwithstanding anything in this section, Section 13, Prohibition and Alteration of Ballistics, whatever. The whole of a gunsmith license in accordance with prior written approval of the authority convert or modify firearms or ammunition. And we have no problem with this requirement. It's just that we want to make sure that attendant with this is a service level agreement in policy. And a use case is, imagine I'm applying for a permit to have a firearm fixed. This is the sole firearm that I carry for protection of life and property. And I'm in a dangerous situation. I can't be sitting around waiting 3 months to get an approval for the gunsmith to fix this. This requires an attendant service level agreement. We're just saying, in policy.
Sorry, so the policy is that any modification of the firearm must be done.
Must be approved, prior approval.
Must be done by a gunsmith.
Right.
And it can only be done on the premises where he's licensed to do so.
We have no issue with that.
Okay, I didn't hear the concern.
To get the permission,
the prior approval we are concerned with. That there must be a policy position for a service level agreement.
Yeah, well, policy, there must be a service standard from the FLA that they will give you a turnaround time within 30 days for something as simple as that.
Well, as I say, if your
almost immediately,
if your life depends on this, and this is your sole firearm, 30 days, I think.
Yeah, it might be long. No, for the licensed firearm holder, it shouldn't be an issue. And in fact, he needed prohibited weapon. If he does a prohibited weapon, he's a criminal. So we don't need it. Again, I see the concern. Mr. Darling, your comments, or Ms.
Mr. Chairman,
Minister.
The modification of the firearm is different from a repairing of the firearm. Repairing of the firearm is done by the gunsmith without any authorization. Right. The modification, now, when you're modifying the firearm, it's a different thing. Authorization would have to be given for modification. So the life and death situation that Mr. Stewart speaks of is a malfunctioning of the firearm for which the gunsmith will fix without any authorization from the FLA. So it's a total different thing. He wouldn't have to wait on FLA for any authorization to repair the firearm if it's defective. But modification is a separate thing now.
Minister, sorry.
That Mr. Dallin has in effect made the distinction. Right. So don't forget now there is a purpose. So each firearm is going to be registered and details are going to be taken for traceability. Right? And it doesn't mean that because you have gone through the registration process that the firearm cannot be used to commit harm, including lethal harm. And it doesn't mean it cannot be mishandled either, which I know you know.
Right. As we said, no contest with, it's just that we're concerned about the service level. All right, so we quickly move on again to section 45.1a. So in whole, section 45.1a says, no person shall be in possession of any firearm or ammunition without the appropriate firearm authorization granted under Part 5. No issue with that, per se. And we note the right, so there was a concern with this in relation to the sport, but again, I guess it's a policy issue. We're saying that it creates no opportunity for anybody to be exposed even in a controlled circumstance. So if I, for example, wanted to take up the sport that Major Nelson engages in, before I can even figure out that I even like this, it would require me to go through the time and expense of obtaining a permit. We just make sure that we enumerate it, just to even figure it out.
Yes, Yes, yes. Yes, deliberately so.
Okay.
Good.
All right, noted. Section 47. And this one I think is, again, from my general licensed firearm community. Section 47, a person shall not carry any firearm or ammunition in a public place unless at the time when the person is carrying such firearm or ammunition, the person has in their possession the appropriate firearm authorization, authorizing the person to carry the firearm or ammunition in that place. We have no issue per se with this provision, save and except. I saw the debate which took place in here. And the thing that struck me most was that it wasn't clear, I don't think it was clearly stated or understood, that most persons actually carry their firearm authorization. It's a card, they carry it in their wallets. And I asked the question, how many persons have ever run out of their house and left their wallets? And I have no issue with the police doing what they're doing.
Dr. Stewart, we can save you the time because we had addressed it and we recognize that a little reprieve is required, okay. And so time within which to make available the authorization and also to delay the prosecution of it. So that issue has been addressed.
This was discussed.
So we can go to the next one in the interest of time.
I think.
For whoever was monitoring our discussion, they were like, we spent about a half an hour on this very, very recently, right?
And similarly, 48.1, the concealed carry issue.
These were discussed extensively, right. And we'll make appropriate modifications while we accept the policy and the principle to prevent criminalizing of the innocent. That's really the base of it.
I thank you. Section 51.1, we're making good speed. A person shall not discharge a firearm in any place except A, in the lawful protection of his person or property, or of the person or property of some other person, in the lawful shooting of a trespassing animal, or under the written authorization of the authority. So our commentary here is that this confines all of the circumstances under which a firearm can be discharged. And I'm thinking that subsection C, which speaks to the, under the written authorization of the authority, would speak to where you have a gun club or range license. So it begs the question. So my friends who go off into the hills to shoot, would they not require an authorization to discharge a firearm in that space? Yes. So, yeah, for the listening public,
intention is that you're not going to be discharging your firearm unless you're authorized to discharge a firearm in any place whatsoever and for any lawful purpose.
Right. So they just want to be clear. As I said, clarification is that they want it to be clear that for the hunting spaces that an authorization will be required for the hunting spaces. We didn't see that defined, and that's what this would suggest.
Minister, if I may. The authorization for shooting wild animals, bird shooting, is given by NEPA. The license holder is not allowed to shoot at will. The license holder, as the law provides, must shoot when life is threatened or under controlled circumstances, under range for training, practice, and so forth. So it is a practice, Minister, that persons believe that they can go in the bush and just shoot at will. It's not allowed.
Well, under the current Firearm Act, Section 23.1, which was, you can shoot beyond 40 yards of a public road, noticeably that has been removed. So we're just clarifying that 55.1 dictates all the places or circumstances under which a firearm can be discharged. But noticeably, as we said, for the hunters, we didn't see any coverage for where it is that they hunt. So they have raised this issue.
Well, what happened there, if I may just say this to
you. Or otherwise authorized by law.
Yes. Minister, what used to happen is that because the law was 40 yards from a main road, persons believe that they could keep a party 41 yards from a main road and carry out gun salutes and believe that the law could not capture them under that provision.
I have a more critical one. I know that, and you know, the killing range is a bit for the new firearms can be quite a distance. I mean, I've seen that's a legal gun still, but they're shooting at each other and 100 yards down the road they go through the window and kill the girl in the room. So there has to be some restriction here, because once you're within the roadway range and the killing range, while the licensed firearm holder goes through a process and is expected to be highly responsible and has learned the sense of responsibility, he can still go out there and discharge the thing, as I say, in a moment. And if it's too close to the roadway, it could end up in a problem. The idea is to ensure that there's a framework in which the legal operator can operate with some levity, and they get the hunting license, fine, and they operate the range in a certain space, because still some risk with it out there, a bit loosely. And we're not going to be perfect in our assessment of all the licensed firearm holders. You know, you're on the range, and I'm sure most of you, or GRA members, you very rarely go on the roadway and shoot at road signs. You never do it at all, right? So you're not going to go to a party of the road and fight out. In fact, you enjoy going to the range and the targets and see how you can handle your rifle. So it's not a restrictive, unduly restrictive. And I think we have to keep it in place, because there are people who, you know, will feel they can practice shooting in the backyard and next thing they shoot in the next person's yard, that kind of thing. So I think this should just let this operate for, you know, when we review the bill, a couple years down the road, we'll look at it again.
Chair, if I may, Dr. Stewart, your question was specifically in relation to bird shooters?
Yes, the hunters.
The hunters, right.
So, right, because
not just bird, but hunters.
They didn't see us.
The NEPA shooters,
right, they didn't see a
NEPA give that license, there's no restriction.
I don't know if anybody on the technical team could give me the answer. Is there a provision in the NEPA Act in relation to shooting specifically? There is. I don't know if
they have to give the license for shooting. They give the license for bird shooting and hunting.
Right.
And there are areas
and
where,
that would be in their act.
And there are areas where the bird shooting is allowed and where it's not allowed.
Right. Except that in this, well, I'm hearing Minister Ford suggesting that or under other law or otherwise as authorized by law should be added here. Could be added here, thank you. But I'm just looking at B in the lawful shooting of a trespassing animal. I'm wondering if trespassing is, well, I'm wondering what we're trying to capture here. A trespassing animal means a bad dog comes into your yard, so you get to shoot it? Or was this meant to deal with the hunter? Because I don't know, you can't say that the bird or whatever they're hunting is trespassing. I'm just wondering if that was what was meant to capture it.
Right. Member Golding.
I don't know if CPC could indicate.
Member Golding, if I could. It was from mainly farmlands. Farmlands, persons on farms, and you have trespassing animal, wolves, wild dogs, whatever, to protect their property, so to speak, trespassing animal. In fact, currently, you have certain places that has pigeons were trespassing animals because of the sheer number of them living there, and they have to be culling them in terms of running them away. So shooting runs them away from their property. So we know we get requests each year for persons to do that. So trespassing animals was mainly meant for the farms.
Chairman, Minister, I think that there is the Pound Act. Sorry. Okay. I think there is provision for some limited amount of shooting of animals that trespass under the Pound Act. So I don't know if that is what it is being restricted to, because I don't believe that you are entitled or able to shoot an animal just for the mere fact that it is trespassing. But I think the Pound Act provides for some amount of well, it refers to specific animals that can be killed by virtue of the fact that they are trespassing. I don't think it is applicable to every animal either. So probably that needs to be because it refers to the lawful shooting of a trespassing animal. So I think that it is restricted by existing legislation. And if that is not the intent of this particular bill, then there needs to be some clarification given to it.
I'm being advised that the NEPA permit tells you what you can shoot and tells you where you can't shoot. Example, in the reserves. It doesn't say where you can. And this provision seems to be attempting to capture or limit where you can shoot. As Mr. Dallin said, we don't want someone to go off in their backyard or on the farmland and discharge a firearm. So we're saying that there's a lacuna here because it doesn't cover what is going to happen with the bird shooters. And they're asking if they are going to require a permit for, let's say somebody goes up to Murphy Hill where they normally have their fields that they feed the birds with the hope of, in bird season, to shoot there. Will they require a permit for that space? They just want to
shoot on their property?
No, which is not
so it's a permissible place.
Which is a permissible place.
I really do think, Chair, that the suggestion that Minister Fort gave as to that addition of or as otherwise authorized by law would sufficiently capture the concern.
But just to remind that Mr. Darling, that if NEPA gives permission for shooting wild hogs and deer, deers and wild hogs. I mean, deer shooting is very important.
Well, deers and wild hogs are not protected animals, Minister, so there's no need for the permit for that. But what they would not be allowed to do is to shoot them in the protected areas.
Right.
They're not protected, but they're usually in protected areas. That's where they go.
Put it this way, Minister. They won't allow them. They won't allow the shooters to pursue the animals in the protected areas.
I'm talking about domesticated animals. They have wild deers in Portland and some wild hogs in Rocky Point, which are good hunting creatures.
They can shoot them, Minister. There's no problem with that.
Within 40 yards. No, that's, I think, no, on a serious note, but they cannot go within the reach of the highway. That's really the issue that I think this was brought up, If a man tell him shoot him see a deer when him drive past on the road down by Springfield, him see a man, him see a deer across the road. Him should not supposed to shoot him from the roadway. Or him go in the hill and shoot him down, chase him down the roadway. Next thing miss the deer.
Mr. Chairman, is that a lawful shooting of a trespassing animal?
Well, I'm talking about a wild animal, Senator. The wild boars.
Yes, I understand that, but I'm just saying that in this bill, is it that you want to extend it? Is it that we are extending it to include other animals? Or is it that we are trying to determine what is meant by 51(1)(b)?
Yes.
Because 51(1)(b) allows for the lawful killing of certain specified animals that are trespassing. It did not say how they are to be killed. The Pound Act has that provision in there where there's trespassing on private land. 27 of the Pound Act, 27A, allows for, an authorized officer, 27. But any owner of land may kill any sheep, goat, kid, hog, pig, fowl, turkey, guinea fowl, peafowl, duck, or other poultry trespassing on such land.
Did it mention cattle?
And that's why I say.
No, I'm asking seriously. I'm hearing it.
When the Pound Act came about, it was because of it protected certain types of animals.
That's why I'm asking, because I think that the Pound Act, I don't think you should be allowed to kill animals just for trespassing.
Right. It does not. It limits it to certain specified types of animals. And so my understanding when I read 51(1) B was that is the reference that it was making to the lawful shooting, or if we took out shooting, but because this is a firearms bill, the lawful killing of a trespassing animal. And it is not just for the killing of any animal. So we need to know what it is that is being. Because when I heard Mr. Darling's comment, Mr. Darling seemed to have extended it to any animal that may be trespassing and creating a nuisance, which could also include cattle, cows, and so forth. I don't think the pounder facilitates that. So I had a particular understanding. It seems that Mr. Darling has one, so I don't know what was the intent of the policymakers in this regard.
Before I comment, my impression is I think this will be carrying over and applied to the in relation to with the Pawn Act. But now you have read it and it is, we're discussing it, and I think we'll have to look at that because the Pawn Act deliberately didn't mention certain animals, including cattle, as opposed to pigs, which are owned by the smallholders. That's really how that old law was structured. Mr. Bailey, you want to comment?
Yes, Chair. I wanted to come in support of what the Senator is saying, that by virtue of the provision specifically saying lawful shooting off, it's giving recognition to whether or not another law may provide for the shooting of the animal. So the Firearms Act itself is not making lawful the shooting of the animal, but if it's provided for in another piece of legislation or in common law generally, then we give effect to that. And that is one basis upon which you can lawfully discharge.
It has to be done under the Trespassing Act, which needs to be amended, Senator, because I think the Act doesn't include cattle and horses, because it was only the big property owners who own them. And the little man owned a few cattle, a few pigs, get him pig shot. And that needs to be examined. But it's not in our effectively, Senator, what you suggest here, we should remove this clause from the, or we would have to amend it.
No, Minister, as drafted, the provision is perfectly fine. I think what the Senator really wanted was just a clarification as to the intent behind the provision.
No, I was just bringing to the attention of the members that this is how I understood it. I am not asking for any adjustment to it, This is perfect as it is. But I believe Mr. Daddy was
it's fine.
And I just wanted to make it absolutely clear that what this is referring to is other existing legislation that allows for the lawful killing of a trespassing animal. And nothing more than that.
Mr. Ford's suggestion that
Chairman, I was looking on, our laws make a distinction between ferocious and tame animals, but Mr. Bailey's point that the intention of the provision is not to create a fresh authority, but to indicate that if you are doing so where it can be done in respect of a trespassing animal, then that would not be regarded as unlawful. I was just looking at provisions under the Town and Communities Act and the Keeping of Animals Act for a distinction and to see whether. Okay. But we'll take that behind us.
We're going into Section 5, and we took the JRA because we figured they cover most of the recommendations. We will actually just let us go a little bit more speedily because we have the senior customs people here waiting for some time, and Mr. Champagne, who are Queen's Counsel. His time is particularly valuable, and his comments, I think, would be required, and I can't keep the commissioner that longer. Okay?
All right. We just two, three quick ones. Just one for clarification. The Section 62.1, the firearm user special certificate, and basically it says, upon application made under Section 57, the board may, after consultation with the divisional commander, grant a firearm user special certificate to a specified group or person, authorizing that group or person, as the case may be, to possess a firearm ammunition for restricted use as specified under subsection 2. Our question there is, we have always had a long-standing problem that we're trying to get resolved. Is it permissible that this could be interpreted to mean an opportunity for, let's say, the gun club to own a firearm? That's one question. And the second one, would this be the provision that covers our international shooters when they come to Jamaica to
It is intended for the international shooters coming into the country.
And the first question about is this to be interpreted as an opportunity for gun clubs? When it's a group of persons, what was meant by group of persons, a person or group of persons?
Because sometimes firearms are coming in, persons are using one firearm, multiple persons are using the said firearm on the shooting range.
All right, thank you. Okay, all right, we'll leave that 73. We'll leave that. 79. No,
Yeah, go through the issues that are
right.
controversial.
79 is a big one for us. So 79 speaks to the storage location. Today, as things stand, the best of our knowledge, the GRA is the sole location that has storage for firearms and ammunition outside of the dealership. So the minute this bill is signed into law, we would be in breach. And we're suggesting that the GRA should be added to schedule, the fourth schedule as a storage location because of our current.
That's not difficult.
All right, Minister, Yes, Minister, as it relates
I know that that's currently done by the GRA, and we could restore that, but we'll go through the usual inspection and formality by the police, etc. Right?
Minister, what the storage that GRA does is different from the storage we're talking here. Dealers are allowed to keep their firearm, the position of their own firearm that they own, the GRA own firearms. Storage of those firearms are okay. What is happening is that GRA is not allowed to store their members' private firearms there. Only the police and the FLA is authorized to store. So what is happening is that the GRA is not a storage location, although it is being practiced by the GRA or the dealers to store persons' firearms. It's not allowed. What happens is that they're allowed to store their own firearms that are owned by them. The dealers and GRA are allowed to do that. What we are not facilitating is the storage of private persons'
GRA
firearms.
owns firearms, right?
Yes.
GRA
yes,
allowed
yes.
firearms. Yeah.
So our concern is this don't seem to cover the members who actually store what we call the restricted firearms, the ones used for sport, that are stored at the GRA, and we are concerned, separate and apart from the dealership, which let's say imported some guns for sale. No. We're talking about the members who have the hundreds of lockers that are in the vault that store the firearms, particularly those used for sport, because our concern is that centralized security is paramount. We don't want the firearms that are there leaving the compound and going.
And I hear you. I mean, the sport rifles are serious weapons, and you need to have the proper storage.
Chairman, let's look at the clause. We've noted the clause to just revisit it. But as it stands now, at such place and under such conditions as may be approved by the authority, which is the FLA. So there is built in the provision for approval in consultation with the divisional commander, or deliver the firearm or ammunition either to A or B. So an approval can be given once the process is gone through.
Executive Director, we'll have to look at this, right? Because I think there's an increasing number of adult sports shooters, and they have different sophisticated firearms that can be quite expensive. And if the storage facility is adequate, we'll have to look at it. The law allows you to approve it. So it's a matter of examining and assuring the police and the authority that the GRA facilities are satisfactory and satisfactorily protected. right?
Chairman, perhaps it may be timely to remind that although it is not the policy to make criminal persons who would have been deep vetted and authorized in any of the many ways that the law provides, it is still not allowing at large.
Right.
Even those who are authorized, very strict requirements will have to be met.
Right.
So we understand the interest from your perspective, but it's not going to be at large.
No, we understand it's not at large, but we're just saying we just don't want to create a situation.
Or too wide.
Or we don't want to create a situation where members now feel that they're in this uncertain place and want to remove those firearms.
The point is well taken, and so you can, because the truth is
I'll
that
rephrase it. It's going to be deep and narrow.
Yes.
part of it, I'd say those firearms they use, the rifles they use for target shooting, are better off being stored where they are being used,
Yes.
rather than traveling around it. Those
Right,
are not
right.
exactly weapons they want floating around
Right,
the place. So
right.
I think the issue will be but I don't want to name the GRA in the law, because again you get the question of special treatment.
Okay.
Once the police and the authority inspects, satisfied, which I know you'll meet the demands, we approve it as indicated by law here. And I said it's common. It's better you have that storage than having a man driving from
Right.
wherever he is with a high-powered target rifle.
Chairman, that phrase, and under such conditions as may be approved, suggests therefore that there's going to be a prescriptive process, some sort of prescribed form, et cetera, and that will be laid out. Thank you.
All right. So I think we have taken it. I think there's just one major comment left, because we really have been going for some time, and I'd love to take the customs at this point.
Finally, Mr.
Yeah.
This one it's not a section there, but I think it's one that we need to add something. Every time a licensed firearm holder passes away, for those of us who are familiar with the law, they probate, it's not in there. Some we're recommending that be added. The probate and administrative process, as smooth as it can be, is 2 years. And what we are proposing is that, similar to the insurance, you have a policy, you can make a nomination, or motor vehicles, you have co-ownership, that we introduce a nomination process, which facilitates somebody to be in a position to dispose of that firearm, so that we don't have this pile-up, this stockpile of firearms that are in limbo. So we are proposing the addition of a process which allows a licensed firearm holder to nominate somebody in the event that they pass away unexpectedly, to be able to dispose of that firearm. And in substitution to, in the event that there's not a nominee, that role falls to the surviving spouse.
Yeah, I see what you're saying, Mr. Stewart. I think the current law, and I think the law will look at it, and Mr. Darling, because I think what Mr. Stewart is, if the person dies and leaves the firearm, nobody can dispose of it before the probate, which makes a non-necessary. If they have to keep it, or the police keep it for 2 or 3 years, it's inappropriate. So either nominee or a structure in the law to allow that the successor of the estate can dispose of it before. I think that too we saw in the comments and is being examined.
Yes. It's something I fully support, Minister.
Yeah.
Believe me, I fully support it, because we have the problem of storage for thousands of firearms. I agree fully with the submission, Minister.
So, Mr. Nelson and your team, I want to thank you all for your submissions and the time you gave to this thing, to the law, because we consider this legislation a very important piece of this. As you do your firearm, your JRA, the Rifle Club, established club, so we're happy you took time to go there and take us through, and a lot of the tidying up you do, in fact, we did in discussion, but thank you again. And this will be going through. We'll come back to Parliament with it again, and as I said, we are open to continued dialogue, because it has taken a long time to get here, and we are where we are. We want to get it in action, fast, but we want a good law out there. So wherever the needs to be changed, we work on it. We have our team working. But thank you again, sir. All right.
Thank you.
Well, I take, Minister.
They may wish to remain inside, if you could extend that invitation to them, since their interest is so high in the matter, if they choose to.
Asking us to remain.
Invite the customs to speak from where they're sitting. If you want to stretch your leg a little bit before, you have to wait a little while. but rather than disrupt you, you could speak from the mic where you are. So I want to welcome Commissioner Ricketts Walker and Ms. Crystal Corbett, the legal person, and Mr. Nicely, the gentleman we give all the trouble for. Right. As the Minister said, if any member of the GRA wish to stay and listen to the custom section, you're welcome.
May I proceed, Chairman? All right, so. Okay, thank you. Good afternoon, Chairman, members of the Joint Select Committee of Parliament, and all present. And thank you so much for the invitation to the Jamaica Customs Agency to participate in today's session. I know you made introduction, Minister, regarding the employees and team members here, but please allow me to continue that introduction. With me is Deputy Commissioner Border Protection of the JCA, Mr. Alwyn Nicely, and Ms. Crystal Corbett, Senior Legal Officer. The Jamaica Customs Agency is charged with the primary mandates of protecting Jamaica's borders, facilitating trade, and collecting revenue on behalf of the government of Jamaica, ultimately protecting our people, society, and economy. These roles, Mr. Chairman, we take very seriously and have implemented a variety of strategies and initiatives to ensure their effective fulfillment. The border protection mandate, while always critical, as all three are equally important, has become even more fundamental as Jamaica grapples with a high crime rate, many of which are undertaken with guns that enter the island, whether through controlled or uncontrolled points of entry. As a part of our border protection strategy is our Border Protection Division of Customs, consisting of 5 units. The work of the division encompasses intelligence gathering, analysis, and intelligence-driven operations, risk-based analysis, assessment, and targeting, intrusive and non-intrusive inspections, enforcement, and investigation, all in support of the agency's mandates. The Jamaica Customs Agency, Mr. Chairman, is the first line of defense at our controlled points of entry. And therefore, we accept that we have a huge responsibility in undertaking our roles and functions with integrity and accountability. Additionally, we have signaled quite publicly to criminal elements that we are waging a war on illicit trade, including guns and ammunition. Evidence, Mr. Chairman, has shown that criminals have sought to use our controlled ports as gateways to carry out their illicit activities. However, the Jamaica Customs Agency continues to combat the mechanisms used by criminals, which has seen the entity seizing 211 firearms, 235 magazines, and just under 20,000 rounds of ammunition since 2016 to date. We know there is far greater work to be done in creating a bigger dent in the gun trade, as criminals are always seeking or using disingenuous ways to undertake their activities. However, we are determined to do the work to achieve the goal to eradicate illicit trade, strategically and tactically. It is against this background, Mr. Chairman, that we have made our contribution to the revision of the Firearms Act. And today, we will speak on those areas that are of keen interest to us as an agency based on our comments that were put forward. So Ms. Corbett, our senior legal officer, will lead the charge, and Mr. Nicely will provide the necessary support. Mr. Chairman, I thank you.
Commissioner, Ms. Corbett.
Good afternoon, Mr. Chairman, members of the committee, and
thank you, members of the jury.
All the persons who are present and online. I will just go through some of the comments that we have with respect to the Firearms Bill. The first comment that is noted is the definition of customs officer. We'd just like to note that the bill entitled the Customs Act 2020 is at an advanced stage before the Joint Select Committee of Parliament, and this is a bill to repeal and replace the Customs Act 1941. Now, we would like to take this opportunity just to highlight a few definitions. Now, in the Customs Bill, officer means A, any person employed in the customs agency, or B, any individual acting in the aid of any person mentioned in paragraph A in the execution of that person's office or duties. Now, we note that there is a slight difference with respect to the definition that is in the current Customs Act, that is the 1941 Act, and we just want to ensure that this is brought to your attention in terms of your consideration. Now,
to say that definition sections usually fall at section 2.
So that is not going to change.
Right.
So we're not concerned about the...
And it would be the definition of the act that is in force.
Yes, that is in fact so. Now, the current definition, of course, includes Revenue Protection Division. That is the 1941. That is excluded from the definition of officer in the Customs Bill.
Those matters were considered.
Very well,
when the
just to
definition
ensure. Noted. Now, with respect to transit, the definition that is in the current bill, the definition of transit as defined in the bill does not take into account what we would refer to as national transit, wherein goods may be transported from one location to another within the domestic territory by different means of transport. It is noted that the definition in the bill speaks to the movement of firearm, ammunition, or other categories of conventional arms through Jamaica to another country where there's no change in their means of transport while in Jamaica. Now, we acknowledge that this may be, what is defined here, you may be taken into account what is commonly known as international transit. But we want to ensure that it is noted that customs plays an important role with respect to national transit, and also highlights as well the revised Kyoto Convention and the definition of customs transit there, wherein it is defined as the customs procedure under which goods are transported under customs control from one customs office to another. Now, in the Customs Bill, there is a clear distinction between what is national transit and transit to export. And to note that goods that are in transit, that are transported from one customs control port to another customs control area, are usually under customs control. And of course, this is because of the nature of the risk that is involved. For example, containers may be placed under seal, or there may be a customs escort. Now, there is also a slight distinction with respect to the definition of transshipment in the Customs Bill, as well as the definition that is in the Firearms Bill. And what I've noted is in the Customs Bill, goods are transferred, in relation to transshipment, goods are transferred under customs control from the means of transport to which they are imported to the means of transport to which they are exported within the area of the same customs office. And this definition is in keeping with the revised Kyoto Convention. Now, in the Firearms Bill, the movement of firearm and ammunition is not restricted to a particular location. What we now refer to in the Customs Bill as transit to export is really subsumed under the definition of transshipment in the Firearms Bill. And we just wish for the committee to just give consideration to these definitions so that there's some amount of alignment and there's greater consistency, especially with respect to any conflicts that may occur with respect to the enforcement of the laws, customs laws.
Valid point. The transit and transshipment were considered in another context, but I think it is useful to just look at it afresh in light of the revisions that are being done. So good point.
Very well. Thank you. Now, with respect to the definition of traveler, I just wanted to, well, it's really a concern. I don't know if it was deliberate, it may have been deliberate, but the JCA has noted that traveler as defined does not include a person who departs from Jamaica. And we recommend that if it is that the committee is minded, after consideration is given, to expand that definition to include persons who arrive as well as persons who depart. Now, departing passengers, Customs has an obligation and a duty at the ports. Passengers have to submit their export permit to Customs when they are departing. Very well. So it's just for consideration that the definition be expanded as is, and I know that in the current legislation that appears to be the same definition, but for consideration to be given.
Yes, Minister, just to say that you have persons who have entered the island not knowing that they have the firearm with them and are leaving with the firearm, and that is why Customs usually detect them going out. License holders coming from overseas accidentally bring their weapons in, but are detected on going out. So there's no provision for them to declare to Customs, even if they do find out. So we agree with the submission.
Very well. Now, I would just like to direct your attention to Clause 66, and that's Clause 66(2)(a), where reference is made to every firearm export permit issued by the board shall specify A, the type of firearm or ammunition, as the case may be, that may be exported under the license, as well as Clause 66(3)(a), where reference is made to every firearm import permit issued by the board shall specify the firearm or ammunition authorized to be imported. The concern or issue that was ventilated is that we are proposing that the particulars with respect to the firearms be specified in the legislation. For example, the serial number, model, caliber, in addition to the type of firearm that is specified there. Those details are included in the current import and export permits presented to Customs, and we propose that the law be aligned with the current practice.
May I though, because we appreciate that comment. However, if you look at 66(1), it already makes provision for specifying the prescribed particulars. So 66(1)(c) says every firearm authorization granted by the board shall contain the prescribed particulars and specify the prescribed terms and conditions.
No, Mr. Richard. Yeah, go ahead.
Yeah. Yes, Minister. What the Customs is saying is that for the import-export permit, they would like it to be specifically stated. The authorization in 66, as Mr. Richards mentioned, my interpretation was really of the firearm authorization, specifically the license and the permits that are granted to carry. No, my interpretation of it. So what Customs is saying for the import permit specifically, although we're doing it now, putting that specification on, there's no requirement in it for that particular type of permit.
But Mr. Daly, I think Mr. Richards is correct, because under clause 57, it talks about the application that may be made for any of the following firearm authorizations, of which the import and export permit are two. And 66.1 then goes on to say that every firearm authorization granted shall at B contain the prescribed particulars, and C specify the prescribed terms and conditions, and such other terms and conditions as are imposed by the board. So a firearm import or export permit granted by the board would contain the particular, whatever the prescribed particulars are, or the terms and conditions that the board is putting in place for those permits. I'm not seeing it as two separate prescriptions. In other words, how I'm reading the policy is that this is really more on the administrative side. So the law provides for it to be included, and I guess it's on the administrative side that you would set out what particulars should come with each authorization.
I think my understanding, they're referring here to the mainly sporting rifles that we send in and out, or say import and export. You need it. All right? All right.
Yes, Mr. Chair.
But Chairman, if I may as well, just to satisfy customs concern, since 66.1 already speaks of prescribed particulars, we could outline all of these things in regulations.
Minister, just accept something. When the import permit is being given for a dealer who is bringing in firearms, that is separate because we don't have those particulars to put on the import permit at that time.
Keep confident that this seems to be referring to the import-export of the sports, the data available. Keep it on that for me. I think I look at now exactly what.
But Minister, what is happening is that here is a conundrum. When you're issuing an import permit for a dealer who is going overseas to buy firearms, we don't have the particulars to put on the permit. When the person who has a firearm in Jamaica who intends to export and re-import, we have all those particulars to put on the permit. That, I believe, is what customs is talking about. Those that are leaving to be returned, or whether the ones that are going over to purchase, we wouldn't have the particulars of those to put on the permit.
Accept the same things. I expect this is referring to sporting firearms, which we give import-export from time to time. And customs asks for the details of them, at least serial number.
Chair, I believe the conundrum that Mr. Darling would have just pointed to is a sufficient basis upon which the provision itself needs to be left as it's drafted, because it then leaves the authority with the discretion to determine, based on the prescribed particulars, what's appropriate in that specific case. If it is that we write in those requirements in the legislation, no, in all cases, if we do not include any exceptions, the particulars would be necessary.
Ms. Corbett, what is the satisfaction? Because somewhat, let me go back to what you're asking again. Let me hear.
It seems to be that we were satisfied with what was just said, Chairman.
Yes,
I will now move to clause 92. Power to search and seize, power to seize conveyance or premises. Now, given the important role of customs in the overall protection of the country's borders from illicit firearms and ammunition, we propose that the provision be amended to include a customs officer acting in the furtherance of the Customs Act. We believe that this is necessary so that customs officers can execute their lawful enforcement functions more effectively. Currently, our powers are restricted in that customs officers are required to apply to a judge or justice of the peace for a special warrant before entering any premises, that is, place or dwelling house. This, if it is that this amendment is accepted, this will further enhance the border protection capabilities of the Jamaica Customs Agency and the government of Jamaica's mandate, of course, with respect to combating gun violence.
What you're asking, let me tell you, that Customs will be given the right to search a premises if they have a high level of suspicion that goods came in and custom goods were there that may include firearms and any other.
Yes, Mr. Chairman.
The current law doesn't allow you to search for uncustom goods at all unless you get a judge's order.
No, the current law provides that we can stop and search a conveyance or search a person. Now, the current law doesn't provide that we can enter a dwelling house without a special warrant. Now, this provision, Clause 92, gives constables, the JDF, and MOCA the authority, once it is that certain things are established, to enter premises without a warrant. That is a power that we do not currently have.
No. What you're seeking, and I understand, I just want to be clear, it says Section 92, you're not looking to have that. You're referring to Section 90, 1 and 2, right?
Yes, Mr.
And you want customs officer added to that.
Right, so where it says, if any constable, officer of the Jamaica Defense Force acting in furtherance of the Maritime Areas Act, customs officer acting in furtherance of the Customs Act, that is the inclusion that we wish to address, or officer of MOCA in the lawful execution of his duties has reasonable cause to suspect.
The current law allows you to do so in the Customs Act.
Not premises, Mr. Chairman.
Oh, got you, in other words. But would we put in this, or does it go into the Customs Act? I have no problem with it. I just want to be at the right place. I'd be advised, right, that you should have. And given the approach, in fact, well, customs is part of the law enforcement and will be subject to the same. Yeah.
Chairman, just so I'm clear, the Customs is currently permitted to search a conveyance. Is that in the physical limits of Customs, of whatever the Customs area is at the border? Can Customs go to search a conveyance, I don't know, on Mandela Highway?
Well, the search of the conveyance, of course, is in furtherance of the Customs Act.
So
once
question.
it is that we're in lawful execution of our duties, under the Customs Act, we can do so.
So you can leave the premises of the Customs agency or the border or whatever and drive to search a vehicle that you think has uncustom goods in it on Mandela Highway?
That is so, and that is the current legislation.
I see. And so now you would want the power to enter a private dwelling place or any dwelling place or any premises in search of uncustomed goods. I just want to be clear, that's what you're asking.
Well,
can I ask another question? What is the complement? I'm assuming these would be border protection officers. What is the complement of your border protection, quote-unquote, force?
In total, we have over 150 members for border protection, that specific division of customs.
Thank you.
Okay. Mr. Chair, just a question here for Mr. Nicely. As it stands now, customs do collaborate with law enforcement agencies in relation to prohibited or uncustomed goods or illegal firearms entering into the country, correct?
That's correct.
So, for example, so we understand that the context of this legislation is really in relation to firearms, illegal firearms. Mm-hmm. So, am I to understand that the extension or the powers, additional powers or authorization that Customs is seeking is to just by way of an example, firearms, illegal firearms enter the country, the refrigerator or the barrel or whatever the conveyance is or container is, your intelligence suggests that it is at a particular residential location, and you wish to, under the Customs Act, use your powers, but you are prohibited under this act because it doesn't allow you to search private premises. My question, in those circumstances, wouldn't Customs have notified, let's say, for example, your collaborative agency, for example, MOCA, the CTOC, those agencies, because you do collaborate?
Absolutely. So there are instances where the JCA is in hot pursuit, meaning we would have probably been on an operation already, and that operation leads to subsequent intelligence that is time sensitive. In many instances, our operations with the JCF and our other partners are planned. So there are going to be circumstances where we don't have the luxury of time to sit down and plan an operation to follow up what we initially set out for. So under those circumstances, we wish to independently pursue that type of contraband. In this instance, firearms.
Specifically to firearm suspicion, well, firearm offenses. So do you think that there is a possibility that, such powers could be abused to be extended to other contraband, not necessarily firearms? Well, you would have had the power under the Customs Act under the Customs Act, you can't enter any premises irrespective of whether it is firearms or contraband. That's what you're saying? Or uncustomed goods. That's what you're saying?
You can't without a warrant.
Without a warrant.
Right.
So, yes. So my question then is, could then this, if we give you such wide powers, could it be abused in the sense that you seek to enter premises? I'm just saying it's a possibility, that you enter premises to find uncustomed goods, which you're not necessarily targeting firearms, but the Firearms Act gives you that power, which you do not have under the Customs Act, to enter premises for uncustomed goods. I'm just asking, just for clarification.
Member Jackson is online. I'm going to ask him to come in before you respond. Member Jackson.
Thank you, Chairman. I'm happy that I'm let in on this occasion. I want to follow up on the point that colleague Member Williams raised further to the concerns expressed by Mr. Nicely, why the power is being sought. I can understand Mr. Nicely using the example you gave, that if you are in pursuit, as very removed from an uncustomed item came in, for example, on the 1st of the month, and 4 days after, 5 days after, through your intelligence, you heard that some uncustomed items enter the country. Wouldn't it be normal, which would be in breach of the Customs Act? Wouldn't it be the case that you will then inform the police, as Mr. Williams was suggesting, to apprehend that person?
So, Member Jackson, under those circumstances, definitely we'd work with our colleague enforcement officers, because those circumstances gives us the luxury of time. Now, there are going to be instances, and we recently faced that, where while on operation, dealing with a totally different matter, information came to the team that led to the recovery of a firearm and ammunition. Under those circumstances, it is for that reason that we are seeking this to be included in this section of the Firearms Act, so that we can act independently in real time to move to recover contraband goods, in this case.
And that is without a warrant?
Without a warrant, specifically as it relates to the entering of premises.
I can appreciate that, Mr. Nicely, that in the course of, and the legal people are there. I know in other legislation, I don't remember which one comes to mind immediately, but there are some wording to the effect that where an activity is going on at the time, as I say, in pursuit or something to that effect, that you can extend beyond that particular point of say, immediate jurisdiction. So would something like that be adequate for you, Mr. Nicely? That will enable you to do just those. I see the point Mr. Williams raised, is to just have a blanket provision to say customs could then get up next week and go and enter premises without a warrant. I think that is the injury that one is seeking to protect against.
So, Member Jackson,
provision where in our operation you can do what you want to do without a warrant. Would that be enough?
I think the Commissioner, for her benefit, is asking that you repeat your question, and I'll respond once you do.
Okay, yeah. I think, Commissioner, welcome. I think there are two distinct situations. One, where the Customs Department receives information that some uncustomed goods, in this case, firearm, came in and at a premises, say as my colleague said, Mandela Highway. Well, having left the customs, the provision as it is that you reference would not allow you to go and apprehend the person on Mandela Highway. If you were to have a wording to the effect to say, in pursuit of ABC, you need to apprehend person B and enter the container or the vehicle or what have you. Would something like that be adequate? Where you are in pursuit? Or during the course of an operation, other things come to mind, come to your attention or knowledge that cause you or require you to enter some premises. Some sort of wording to that effect would be enough for you?
Member.
Mr. Chairman, before the Commissioner comes in, I just want to ask, which is a follow-on from Member Jackson's question. The Customs Bill, you said is presently before a Joint Select Committee. I think Ms. Corbett said that.
Yes.
Correct? All right. They have indicated that in the existing Customs Act, there is no provision for them to enter into private premises in pursuit of uncustomed goods without a warrant. That's how I understood them saying. Have they made any submission in that joint select for their power to be expanded there? Because I believe that we are going to end up with an inconsistent situation if we were to facilitate it under this bill and it is not contained under the Customs Bill. So I am asking, have they made a submission, and what was the position of the policy makers, members? What was the position in that joint select under the Customs Bill? Thank you.
Mr. Sibley want to comment. I think you're a member of the Joint Select Committee.
Yes. Really, this request, to my mind, is awesome for the custom officers are asking. And I just want to get an understanding of what is the mischief in this request, in that, and also what has been your experience with working with the police in in pursuit of illegal firearm at dwelling houses.
So in terms of our
dwelling premises, generally. So I want to know, how was it hampered? And your success rate, or is it not that the police are successful in carrying out their work when you collaborated with them or notified them?
So again, the JCF and the JCA enjoy excellent working relationships. That's the first thing I'd want to put on the table. Now, despite that, however, there are occasions on which we, the JCA, are in receipt of particular information, and it happens on the fly. So you are conducting an examination, you're conducting an operation, and you come into information that requires an immediate response. So you would hear that something is at X location and it is being moved, it is about to be moved, it's going to be moved in 10, 15 minutes. There may be a difficulty in having the JCF assemble and move at that time, depending on what their own priorities are, depending on where they are. So given those, for want of a better term, limitations, the JCA is seeking to be included in this section of the bill so that independent of the JCF, we can move to remedy that situation or to deal with that situation in almost real time.
And the second part of my question, how often, how often does this happen that it would warrant that amendment to the bill to include the custom officer having this authority?
From time to time, I can't give you a definite count, but from time to time we encounter these situations. But the fact of the matter is, regardless of the frequency, regardless of how often it occurs, the fact that possibly something slips through, even one, because of a limitation by either of the parties, is in my mind enough to warrant us at least being considered to be included in this section of the legislation.
Yeah.
So if I'm sorry. All right, let me.
Mr. Nicely, when you act with a warrant, are you acting then on your own, or is the JCF normally accompanying you when you're executing that warrant?
Right. So,
what's some nuance?
That can happen under either of those circumstances, because there are times when we do act independently and there are times when we act in collaboration with the JCF. So we are not limited to acting with the JCF. We can act independently.
The question that Member Sibley's asked, though, in relation to how often, is not a question that I would wish you to answer in terms of from time to time, because it is precisely that kind of data point that needs to be analyzed in order to determine whether or not the request by the JCA is a reasonable request. You are asking for the Parliament to consider allowing you to enter a premises, which includes a person's home, business place, or otherwise, and to search for illegal weapons that you feel have crossed the border without a warrant. Without a warrant. And so it can't be that you say from time to time this happens, I would wish for Customs to provide this committee with data as to how often Customs encounters these situations. What experiences do you, a better understanding of what the difficulty it is that you have in engaging the Jamaica Constabulary Force to assist you in those circumstances, so that we can make have an informed analysis of the question you're asking in consideration of the framework and regime of this bill that we're seeking to pass. Thank you.
All right. I think, Commissioner, the rationale given is quite clear and logic, but the comments raised in terms of incidents and that would need to be borne in mind. What I said at this point, and bear in mind that some of the hesitations would come from, in addition to lack of data, that Customs is still seen primarily as a revenue organization looking at protecting revenue as opposed to general law enforcement. While we are aware, the direction we're moving is to strengthen our border control, and what I'd say is the matter has been raised, a reasonable, logical rationale has been given. I would take it back to the policy team and we'll look at it, but the data that Senator Golden asked, if there's some data can give us in terms of how many times you are caught with, the need to move immediately. And I can see the incident. You are told to go to address Y, there's uncustomed goods, and why the address why I say, no, it's not really that house, the next house next door. You don't have a warrant. And even if you had a warrant for house 1, you don't have a warrant for house 2. And therefore, by the time you get out to go to house 2, it will go. But some data on that could be useful, and I know that's how things can operate. I said the rationale for it is seen. So allow us to take it back for due consideration, and if we can provide us with some data in the meantime, right? Commissioner, you want to say?
Thank you, Chairman. And so the agency will provide the data as requested. I know, Chairman, that you indicated how the agency is perceived as a revenue collecting agency. And I trust that the members here recognize that our mandate expands quite wider, our scope is quite wider, and the nature of what we do must be understood, especially by parliamentarians, that we have a strong law enforcement role that must be supported for us to be able to effectively do the job that we do. Now, in the pursuit of ensuring that that any illicit firearm and ammunition and component parts passes through the port, that we are able to detect, and if we have immediate intelligence that something might go awry, that we must be in a position to be able to retrieve those items as quickly as possible. So I'm hoping I understand the constitutional rights as it relates to a dwelling place, and that we normally go with search warrants, and I will also ensure that we present whatever the data that we have as relates to on the times that we go into dwelling spaces with search warrant, because that is something that we do, as well. And so I just would like for the members to bear in mind the role of the Jamaica Customs Agency, and that we are in this fight, and we need to be in this fight, and we need to be supported to be in this fight.
Thank you. I think Mr. Richards wants to say something. Member Jackson finished his comment as well. I remember
Mr. Chairman.
Yes, Senator Sinclair.
If I may, I don't think I got any response to the question I asked. The Customs Act and the Jamaica Customs Agency generally deals with uncustomed goods, whatever they are, whether they are uncustomed firearms, bullets, component parts, whatever, anything that is uncustomed, right? Did not get the appropriate permits to enter. I am asking what is the position that they have taken? Because if their primary act does not facilitate them entering premises in search of uncustomed goods, it does not define it as excluding anything relating to a firearm. What is the position there in respect to that bill? Is it that they are also asking for the ability to enter into a private premises without a warrant in search of any uncustomed goods? Any uncustomed goods, because this one is just specific to where an offense is committed under this act, which is a particular act dealing with firearms. So that was my question, and I did not get a response.
Yes,
so is it that they're asking for it here? Did they ask for it there? Because if they have it there, and if it is going to be included in that act, whether it is included here or not really doesn't make much of a difference. But if it is included there, and it is a agreement of the Joint Select and Parliament and the policymakers that it should be included there, then I don't have a problem with it being included here.
Yeah.
But if it is not being included in their primary act, which is the Customs Act, then I would then ask myself, if they have not made a submission for it there, why are they making a submission for it here? I'm just asking that question.
Yes.
And I did not get the answer to it.
Thank you, Senator. I think, I get it much clearer what you're saying. If currently you're not allowed to search a private premises without a warrant. Is a new act bringing that on stream? But you can search a conveyance on the road if you suspect it has uncustomed goods, etc. But you're not allowed to go to a private premises.
Right.
You're asking for that now to be included in the bill. But what's the status of that in your bill? Because I think, Senator, your bill would cover all uncustomed goods, including firearms, which is a challenge. If we put in this, it would be dedicated only for a suspicion of firearms being there.
If I may just read
What she's asked for is a consistency, which is reasonable, that if it's going to give you the right to search a private premises without, as a law enforcement officer, then both bills should contain it. Or in fact, if you have it in your primary bill, you wouldn't even need to do this bill in a specific way.
Mr. Chairman, the Customs Act, 1941, Section 203, if I may just read, states that if an officer has reasonable cause to suspect that A, any uncustomed or prohibited goods, B, any books or documents relating to uncustomed or prohibited goods, or C, any computer equipment that he reasonably believes to have been used in connection with and to contain evidence relating to the importation or attempted importation, landing, removal, conveyance, exportation, or attempted exportation of any uncustomed, prohibited, or restricted goods are harbored, kept, or concealed in any house or other place in the island, the officer may apply to a resident magistrate or justice of the peace for a special warrant in relation to such goods, books, documents, or computer equipment. And where in relation to an application under subsection 1, the resident magistrate or justice of the peace is satisfied that the issue of a special warrant is justified, he may grant the special warrant authorizing the officer to enter and search the house or other place referred to in his application by day or by night, B, open the lock of a door, box, safe, or other receptacle which the officer has reasonable grounds to believe is relevant to the search, using such force as may be necessary, and C, seize and carry away any uncustomed, restricted, or prohibited goods, or any books or documents relating to such goods, or any such computer equipment as may be found therein. Now, to answer the question, a similar provision is at clause 218 of the Customs Bill. So the bill as it stands does not provide for search of a premises without a warrant.
Good. Thank you, Ms. Corbett. And so then, I am asking, Mr. Chairman, they are presently before a joint select committee in respect to their primary bill. Have they made the submission for that to be expanded to allow them to enter without a warrant into those private premises? Have they done that?
request that we're making now is specific, and it is specific.
No, I am speaking about when you appeared. Have you appeared before the Joint Select Committee on the Customs Bill?
The answer to that, member, is yes, we of course have, but we are a part of the technical committee. However, as it relates to the customs bill and in regards to this provision that we're talking about, no, there's, as is presented by Ms. Corbett, that is how it is represented in the bill.
Okay, fine. So I am asking, have you, as part of the technical team, sought to expand that provision that is in the existing customs bill?
No, member. Our submission here.
If you have not, hold a second. So if you have not done that in your primary bill, why are you making the submission here? That's what I'm trying to understand. Why?
We are making the submission specific to the firearms and ammunition. That's what we're making the submission.
I understand that you are making, but everybody understands that. We understand that, but I'm asking you, what is the logic in you not seeking to get it there, but you are coming to seek to get it under this? And I think that is what is causing, Member Williams. Is it going to be something that can be abused? Why have you, as part of the technical team, not sought the ability to enter into private premises under your customs bill? You seem as if you want to come through the back door then to get to where you want to get to. That is my view, right? So I have a concern when it is being done in that way and you have not made that submission and you are part of the technical team that can influence the formation of that bill. I'm just asking why.
So that comment, member, in terms of backdoor, very unfortunate. It is certainly not.
I apologize right off the bat if it causes offense. I'm sorry about that.
All right.
I'm going to ask Mr. Richards. He wants to comment on it before your comment, Commissioner. You're not again.
Chairman, So we had, at the technical team, we had actually considered the request from Customs, but when we look at how the provision is drafted, we were a little bit concerned because the reason why it was narrowed to only law enforcement in its truest sense was because the provision in the chapeau says reasonable cause to suspect that any conveyance or premises being used in the commission of any offense under this act. There are several offenses under this act outlined in the 6th schedule as well in part 2. So it will be very difficult to grant some of these powers of search and seizure to Customs, which is, I'm not trying to say not law enforcement, but not the truest sense of law enforcement in terms of investigations.
Commissioner, before I comment, because we have spent some time interrogating the issue, and I've seen some rationale. I think I'd like to discuss this further at the policy level because it is true that the issue is being raised by both Mr. Richards, why he didn't put it in, and by Senator Sinclair. I don't think the term backdoor that was unfortunate in saying that you're seeking under this as a specific issue as opposed to general customs act. But we're at a point where we're going some transitional activities as well in terms of policy and the role of customs. So I'd rather say, you have made the point, let us discuss it elsewhere, and we go through the bill, because the move to ensure that customs which controls our legitimate ports be brought more into the law enforcement activity of customs be brought to the forefront, as you have indicated in some activity recently in the media, but it's also an activity being done at the national security level. Let us discuss this and see how it goes, because there is cause for concern not having it in the general bill as opposed to a specific bill. So we need to discuss it at the policy level and see where we go. And I said the current move to ensure that the customs agency, the head of customs is a part of our National Security Council, is a significant step which is on very recent. So the point has been made. We'll examine how it impacts on the overall bill. Minister.
Chairman, I think you have said it. The ask couldn't be inserted in the clause as drafted because not every offence under the law relates to the duties and functions of Jamaica Customs Agency. But it is understood where you are coming from, and as the Chairman said, we will look at it in the other forum.
Go ahead, Mr. Horn.
That's it?
That is it. Thank you, Mr. Chairman, members.
Thank you. Thank you so much.
Thank the agency, Commissioner Walker and the team, and for your interest and the points you have brought to our attention.
Yes, and
we know you have been pretty active,
yes,
especially in recent time with your agency. And we all have the entire country have to get behind this, get the illegal guns off the street. It's a problem, and certainly government agencies, especially those in law enforcement, have an even greater responsibility. So thanks for your presence, and we look at that.
Thank you so much, Chair.
All right. Yeah. But we continue to increase the collaboration between the critical agencies, customs, police, MOCA, etc. All of that in the pursuit of
Indeed,
this
sir.
critical time. Thank you. I know you made, I suggest the members who are here from morning, especially my colleagues, have a drink of tea hot. And Mr. Champagne has been waiting himself from QC from the private bar, Mr. Champagne. Members say if you keep them, you might have to provide them with lunch as well. But we'll take you on the. We'll just stretch for a minute, but we'll take you up before we take any long break. We'll just take a minute to Shani. You may come to the front, or you can speak from where you are once the mic is working.
Chairman, we would ask them to sit in the area. Just ask the orderly to just shift over so they would come to the presentation area.
Jamaica and its workforce are advancing quickly. Life-changing opportunities are arising. You need training and support. We are the Renewed Heart NSTA Trust, committed to providing new and emerging skills training and opportunities.